Good afternoon, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Michael. Michael, thanks first of all for joining us. Perhaps maybe you can tell us a little bit about your background, and then we can get started talking about criminal law and provincial offenses.
Great. Thank you for having me. I'm excited to be here. Just a little bit about myself. I have been working or have worked for the city since 1991 and recently retired. And I initially started with social services and I moved into the I guess, investigations branch that they had for welfare frauds. And so I assisted with investigators who got tips from the public and investigated welfare frauds. And as a result, if there was sufficient evidence, I would compile that evidence and a package together and present to Crown attorneys, to the police. And if they believed there was a criminal charge that was warranted, they would go out and do the arrest, and I would coordinate the witnesses to attend court and present expert witness information during the criminal proceedings for welfare frauds. From there, I moved to prosecuting for the city, and in 2000, I became a prosecutor. And shortly after that, I was successful in a management call and have been managing the court since 2005 until 2023, and at which time I retired and was fortunate enough to get a job with Centennial College teaching in the paralegal program, which I'm currently doing now.
Perfect. And I know obviously this semester you're teaching a couple different classes, and perhaps you can kind of tell us a bit about what that's like, and then we'll kind of look at those areas because they kind of intersect well, especially given your past experience about kind of for both of you, your students and anyone else listening, kind of an overview of what goes on the POA side and then what goes on the criminal side.
Right. So initially, I started with teaching rules of evidence, and so that entailed all of the requirements of what to expect in court and what the evidence is, and how to present evidence, exclusion of evidence based on charter issues. And then I currently am teaching a criminal summary convictions course and a provincial offenses course. And they have a lot of similarities, but they have a lot of differences as well. So it'll be an interesting discussion for this evening.
Perfect. And let's get right into it then. And sort of obviously, you have all that wealth of experience, being a prosecutor and managing there. That maybe you could tell us kind of what changes. And I know there's some changes actually right off the bat we can talk about that are planned. Now, sometimes these don't ever come to light, but you may have that perspective. Obviously, I think parking tickets, right, went through a similar process to what they're proposing with the red light camera and the speed enforcement. So maybe you can tell us kind of a little bit about the background from prosecution perspective of how those changes came about and what's the difference between how they used to be done parking wise and how they are done now, and kind of how that would bode for again, even like someone who might be listening to this and come October, November, December, or whenever it'll roll out, then they're like, oh wait, I don't get a trial now for my red light
Right.
camera. And then somebody's going to be complaining, hey, it's not fair. But like, I mean, how successful were people on those, or are people on those, generally today anyways?
Right, right. So when you look at provincial offenses, you can look at owner liability offenses. And initially, when you look at parking violations, those are all owner liability. So we found that previously, when anybody got a parking ticket, they can request a trial, and 12, 13 months later, actually have a trial, which we found, with the delay and the number of defendants wanting to contest their parking violations, that the courts were just jammed. And so the administrative penalties came into effect, and because they're owner liability, they really don't affect a charter right in the sense that there's no mobility rights if you're convicted or found guilty of a parking violation. There's no jail time. There's no serious repercussions. There's no criminal record per se. just a monetary penalty. So in that sense, the rights to have a trial and being able to contest it still through a screening process simplified a lot of the ways in which parking violations are dealt with rather than going through the courts is going through a screening process. So we do have staff at the City of Toronto that will review parking violations, and there is still an ability, if you disagree with that decision from a screening officer, there's still a tribunal that you can go to. So there's still an appeal process, which is independent from the screening from the city. And as a result of the red light cameras and the automated speed enforcement that is starting to expand within the City of Toronto for, if anybody is familiar with Vision Zero, it's really trying to reduce the amount of pedestrians that are being struck and the safety of the public that are using the roads, school zones, especially for automated speed. And those are being expanded. And as you can see, parallel to the parking violations, they are starting to really fill our courts as well. So with automated speed and red light cameras, similar to parking violations, they're owner liability. So there's no demerit points, there's no conviction on a driving record. It's just a monetary penalty to the owner. So the owner of the vehicle are responsible for any penalties that are associated with those offenses.
Yeah, and so are no in your sort of experience there, kind of are people successful, when they take these to trial? I mean, are these the bulk of what's coming to court, or is it just a mixed match of different, general traffic stop, where there's no cameras by the police? Because again, people don't realize that, you don't have to have a camera to still get a speeding ticket or
Right,
a red light ticket, right? So, what
right.
do you find is kind of making up the bulk? I mean, I know obviously there may be numbers, but are these kind of the new parking tickets, and this is the need for that, or is there any success from the defense side on, hey, I had to, I came to a stop, or I was turning or whatever. I don't
Right.
know how successful. I mean, and maybe you also might want to. I know there's a bunch of things in here at once, but just the absolute liability. I think another concept you talk about in provincial offenses and criminal law. Well, not in criminal law, but important to know that as well.
Yes. Yeah. So when it comes to owner liability offenses, the evidence is the evidence. So even with parking violations, I can only speak for the City of Toronto. I know that the enforcement officers have a handheld device which they issue the parking violations, but it also has the ability to take photographs. So they will take a photograph of the vehicle that is allegedly parked in violation of a bylaw, and therefore that evidence is being provided to the screening officer. And if the defendant wishes to review it as well, they are able to look at the photographs as well. Similarly, with the red light camera and automated speed, the evidence is the evidence. And that's not to say that there's absolutely no defenses that are available, that it's pointless to contest your charges. And that's the whole point, is that if you believe are grounds that where you can seek a remedy, so to speak. And if I give you an example of the parking violations, the screening officers have the ability to screen the charge to see if the evidence is clear, and where and previously with the courts, when it came to trial, the balance of probabilities didn't exist. We had to prove the charge beyond a reasonable doubt when it came to court. But now with the administrative penalty, the level that is sought in determining whether an offense occurred is now on a balance of probabilities. So that's another legal term that we can get into a little bit further. But in that sense, it gives the screening officer the ability to either cancel the violation if they believe there was an error or an omission or an exemption that may have occurred. They may decide on reducing the penalty. So there may have been mitigating factors. And there's another legal term that I've just thrown out, and we can discuss what a mitigating factor is. But there may be mitigating factors or an explanation, so to speak, that doesn't go towards whether they committed the offense or not, because they are absolute liability. It goes towards, well, yes, I understand your situation. Perhaps I could give you a break on the monetary penalty. So there are reasons to screen or request for screening, because you can either, again, cancel, or you can vary the amount of the penalty, or you can affirm. If the explanation isn't sufficient to believe that there should be an exemption or a reduction, then the penalty is the penalty, and that's the owner would be notified of that. The other benefit is that if the penalties are affirmed, the screening officer can issue, extra time to pay the penalty. So if you have any financial difficulties that you want to explain or want to discuss, then they may be able to give you, your penalty is not due for another 3 months or 6 months. And there's sometimes a higher penalty for the disability parking, where the penalty could be $450. And we have some discretion to reduce based on certain situations, but we are creatures of statute. So we can't say, well, we'll reduce your $450 penalty down to, $100. We have limitations as well. And because the statutes dictate how far we can go in terms of reductions, a screening officer can only reduce it down to a minimum, the statutory minimum of $300. But again, if they want to go to a tribunal and explain that they have a financial difficulty, the tribunal may be able to provide them with further relief.
Perfect. So I think maybe now we can kind of, there's quite a bit to unpack, but maybe we can look at, outside of those types of, and we can come back to it, but what happens, maybe let's look at an example like this. Let's say somebody is charged with careless driving, and maybe they also get a criminal charge of dangerous driving as well, right? And I think this is great, because obviously you have the two different classes, and there's two different, there's a lot of similarities but a lot of differences, as you pointed out, of how things progress. So let's start with the careless driving. So come up, let's say someone's driving on, I think yesterday there was something on the DVP, right? That they were, I don't know if that, someone's driving at excessive speed, collides, smashes into, the guardrail, and causes a pile up, and gets charged with careless driving, right? So what happens? What's next for them after they get issued that ticket there at the DVP, and what are their options next?
Right. So when you talk about the Provincial Offences Act, there's three charging sections: part ones, part twos, and part threes. Part twos are mainly parking violations, which a lot of municipalities have moved away from and have moved into the administrative penalty. But we look at the part ones and part threes. So depending on the discretion of the officer, a careless charge could be charged under a part one or a part three. So depending on the stream that you follow is based on how the officer decides to issue the charging document. On a part one, if you're charged with a careless, then you have the option of just saying, yes, mea culpa, I am guilty. I just want to pay this out of court. I don't want to pay paralegal or take the time out to go to court and go through that process. I just want to pay for it. So on a part one, they have the option of the pay out of court settlement, and the set fine, including any victim fine surcharges, would be associated with a part one, and they can simply go to a court within 15 days and pay for it. Or they can decide to, on a part one, they could decide they want to meet with a prosecutor and say, you know what, there were certain circumstances that may have contributed to why the accident had occurred. And generally during an early resolution meeting, the prosecution can review the facts and take a look to say, okay, you know what, there are mitigating factors. I understand what your submissions are. If you want to plead guilty, you can plead guilty to a lesser or included offense. So the facts still have to fit the offense itself. And if they decide to plead guilty to the lesser included, they would be brought into a breakout room with the justice, and they could plead guilty based on, you know, the justice being satisfied with conditions of them pleading guilty. And we can talk about that later on in terms of what the conditions are on a guilty plea in POA court. Or they can say, you know what, I don't believe I was guilty. I was cut off by another vehicle, and the accident occurred as a result of somebody else's action, and they can then request a trial. So within 15 days, they can go to a court, complete what is called a notice of intention to appear, and upon submitting that to the court within 15 days, they will get a trial date scheduled, and a notice of trial will be sent to them, at which time, prior to the trial, they would be requesting full disclosure on what evidence the police have in terms of why they laid the charge, what evidence they have in terms of witnesses that may have observed what happened, and they would be entitled to full disclosure. Conversely, if the officer believes that it was a more serious offense and the set fine for the careless isn't sufficient enough as a deterrent, or whether it's be a specific deterrent or a general deterrent, and they believe that they should be issued a higher penalty upon conviction if they are convicted, then they can go by way of Part 3, and at which time the officer would give them a what is called a snap summons or a 104 summons, and they would have the charging section and the short form wording, all the required elements on the charging document, and they would simply give them a return date, which is what is called a set date or a first appearance. And the person charged would have to appear in court on that date, and then they would have the option to, again, discuss the case with the prosecutor and either be given a plea resolution to a lesser included, or at that time be given their disclosure to review, and they can decide how they wish to proceed at that point. If they want to put it over for a pretrial with the prosecutor at that time, if they want to schedule a trial date, or if they want to plead guilty at a later date and put it over to be spoken to and get that disclosure, review it, and perhaps get legal advice at that point as well.
Perfect. Now, I mean, so the other sort of part of our hypothetical was, well, what if it was a criminal charge, right? Like a dangerous driving, let's say dangerous driving, which again, also people don't realize. I think that some of our students have intro to law, and they kind of use this example of, you know, the provincial and federal government powers, right? That, you know, it could fall under either. It falls under both, right? It's not.
Right.
So what happens there, on the criminal side, right? Of you get this charge, right, of dangerous driving. What are the options there for somebody in that situation?
So that would mirror the Part 3 summons. So they would be issued a 106 summons. So they would be given either a promise to appear, and then they would be given a future date to appear in court, and then the officer would have to swear in information, and that would go through the criminal process, and they would have to appear on their first appearance date and make answer to that offense. And again, similarly to a Part 3 offense, they would be provided disclosure, and they would be provided perhaps a discussion on, you know, if there's a lesser included that could be provided to them. And then if they want to have a trial, at that point, they could schedule a trial, but the repercussions of a criminal charge is more serious than what would happen through provincial offenses. So provincial offenses are deemed to be less serious, and they're more regulatory in nature, whereas a criminal charge is that it's more to protect the public safety. That is more paramount. And so they could go through the criminal proceeding similarly to Part 3, where they would have to attend court on the first appearance, and they would have to either enter a plea or receive their disclosure, and then have discussions with the prosecutor for any possible resolution. And again, they can choose at that time, if they don't have legal representation and they're appearing on them by themselves, they can say, can I adjourn this to a future date so that I can get some legal advice or review the disclosure that's just been provided to me, and then at the next date decide whether I'm going to proceed to a trial or to see if there's a resolution to take place at that point.
Perfect. So you mentioned disclosure, and I guess this is probably the next step here for the our hypotheticals. So what's typically provided, on, part one versus part three, provincially, and then on first appearance at a criminal matter, and then what are the steps there? Again, with there may be paralegals listening that are just taking on a POA matter or a criminal matter for the first time. How do you request additional disclosure, and how are the processes there different between the examples we have?
Good question. So when anybody is charged, depending on what stage you want to proceed at. So if it's a part one and you want to go through an early resolution, it's very unlikely that you would get disclosure. The early resolution is indicating that you understand what you're being charged with and you want to have a fruitful discussion with the prosecutor, and at that point indicate whether you want to plead guilty. So you probably wouldn't get disclosure at an early resolution meeting. However, on a part one, if you decide to put it over to a trial date, at that point, it would be prudent for the defendant or agent to request disclosure. In fact, there is case law to support that before proceedings and even a guilty plea, the defendant and or representative should have disclosure to understand what they're being charged with and understand what the facts are, because essentially when we talked about some of the conditions the justice has to have in accepting a guilty plea is that the defendant or agent has to agree to the essential elements of the offense and the essential facts of the offense. So that's one of the conditions that are looked at when justices accept a guilty plea, and they have to go through a plea inquiry. And again, that's something that we can discuss later as well. For a part three, they wouldn't get disclosure until their first appearance. And at that point, they would get any notes of the officer, any witnesses, if there's any dash cam video or body cam audio, the defendant is entitled to that. One of the things that have come up within the last few years is what is called a McNeil report as well. And that is any disciplinary records or charges that the officer has faced. And that could be determined whether there's a bias involved or if there's any ethical questions of the officer that can be raised at a trial. So that may also be one of the parts of disclosure is the McNeil report. If it's an accident, they would have the accident report and the details of the diagrams of the scene. They would be eligible to receive any statements of any third parties, such as any else that were involved in the accident that has provided disclosure, or sorry, a statement to the officer. That would be part of the disclosure as well. And part of the responsibility of the prosecutor is to properly vet the disclosure. So even though you've asked for disclosure, you may not receive all of the information. There might be some areas that are vetted out, such as personal information, and that protects the integrity of the trial to ensure that the defendant doesn't approach the witness to either threaten them to say, hey, if you come to court, this is going to happen to you, or coerce them in another way. So privacy is important in terms of vetting disclosure. And so when you ask for disclosure, you may have some information that has been vetted out. So that's essentially what would be received in disclosure for any motor vehicle situation, whether it be a part one, part two, or sorry, part one, part three, or criminal offense.
Yeah, is there anything different on the criminal side there? I mean, with respect to what you'd be getting and that first appearance comparatively to a part three, let's say?
So at a criminal proceeding, disclosure is generally given to the defendant or agent but it can be more of a shell type of disclosure, where as disclosure is an ongoing responsibility. So as information, as investigation comes forward, that is an ongoing responsibility. But essentially, for if you're looking at a potential charge of either careless or reckless driving under the criminal code, the disclosure would be essentially the same from the officer. It would have the any witness statements, any diagrams, any audio or video that was taken by the officer. And there would have to be a level of discretion that is provided by the officer on why they decided to go criminally as opposed to under the provincial offenses. So there has to be some aggravating factors that are associated with the manner in which the defendant was driving. And so that is one of those things you have to look at in terms of proving the case. Because when you're looking at provincial offenses, you look at strict liability. So you have the defense of due diligence. Whereas when in the criminal realm, the other difference between the two is that when you're prosecuting something criminally, you have to prove both the mens rea and actus reus. So it's a higher burden for the prosecution to prove in the criminal sense. So for a criminal charge of reckless driving, there would have to be evidence of recklessness or evidence of should have known or ought to have known that the condition that they were driving would have caused serious property damage or injury in the event an accident occurred. So the evidence has to be that it's a higher burden for the prosecution to prove a criminal charge than through the provincial offenses.
Yeah, I mean that's an interesting point because I see these video. I think someone the other day was like they were gonna miss the exit off the 401, I think the 427, and they came to like a complete stop, and luckily nothing happened. But I mean, situations may be like that. I mean, or sometimes it may be like what happens as a result, right? Like uh no, there's different ranges, right? Like somebody may run a stop
Right,
sign, nobody gets injured, but like someone
right,
runs a stop sign and someone may be killed, right?
right.
And all of a sudden, essentially the same kind of, mens rea you may have had, right? It changes, right? In the sense of, well, now we want to prosecute criminally because, of the consequences of the same kind of
That's right.
behavior.
That's right.
The other thing, though, is also you could start with a criminal matter, right? And what happens if, the Crown Attorney reviews it and says, you know what, maybe we can look at a resolution where this is no, even on impaired driving, right? Where they say, well, look, maybe there's some problems with the breathalyzer testing, so maybe we can have you plead guilty to careless driving instead, right? So maybe you could kind of explain a little bit of how sometimes matters come over that way. Even in our scenario, I think there's a likelihood of the Crown reviews, hey, you know what? Maybe they don't have those aggravating factors here, or maybe to prove this at trial, the mens rea element might not be there. But on a careless, I think we probably could be successful.
Right. So one thing to note when you're looking at the provincial offenses and the criminal realm, way back in the day when the province downloaded the Part Threes down to the municipalities, one of the things that was part of the memorandum of understanding is if there's a criminal charge that's associated with the provincial offenses charge, the federal crown or the would have jurisdiction over it. So even though there's a POA charge, if there's a criminal charge associated with it, it goes to the federal crown. So in that sense, when it goes to the Crown Attorney for a criminal charge, they do have the discretion to look at other possible legislation, including the provincial offenses, and amend the offense from a criminal charge of reckless driving to careless driving. So they do have that discretion. And they do have, as long as they're consenting to that amendment, that can be done in the criminal realm.
Perfect. So then I guess we got this disclosure. Maybe you're missing some officer's notes. Maybe you're missing if there's, some video footage, maybe not, but maybe there might be video footage, I guess, from a third party. Everyone has these dash cams nowadays, right? Or somebody's pulled out their phone, passenger. But what do you do, I guess, if you want additional disclosure before, again, wanting to make that decision, whether perhaps pleading guilty or perhaps going further along in the process?
So it touched upon the Law Society rules in terms of if you're a paralegal and you're representing somebody, you must request disclosure. So and that is an ongoing process. So if you believe that you have not received full disclosure, the prudent thing to do is, upon discovering what may be missing, is to send a secondary request to the prosecution agency that is dealing with the matter. And typically, it can take 6 to 8 weeks to receive disclosure. So if you have not received full disclosure within that time period, as a prudent paralegal, you would be submitting a secondary request on the 8th week saying, hey, I've received some of the information, but not all. This is what we believe is missing. And then wait another 6 to 8 weeks to see if you actually receive that information or a reply. The prosecution agency should be replying by saying, hey, listen, you've asked for it, but it doesn't exist, or we've asked the police for it and we're still waiting for their response. So you should get some response from a secondary request. Now, if you don't receive any further disclosure at the 6 to 8 week point of submitting that request, you should request a third request. And this is very important for a paralegal to understand, is that when you're looking at the similarities between POA and criminal, POA is considered quasi-criminal, whereas some of the rules also apply in the POA world. And disclosure and the right to disclosure under Section 7 of the Charter also applies to the provincial offenses. So by documenting and ensuring that you have that documentation, if you do not have full disclosure on your trial date or prior to your trial date, a paralegal can submit a charter application under Section 7 to look at the remedy under Section 24(1) to have the matter stayed. So that is very important for a paralegal to understand, is that submitting the first request is not your full responsibility. You have to document, you have to ensure that you follow up, you have to ensure that you diarize everything so that if you do not receive full disclosure, you have all the documentation to indicate that you've done your due diligence and the prosecution agency has not fulfilled their obligation, and you will be more successful in arguing your charter application under Section 7.
So since you brought up charter applications, I guess that's one of the things that could be raised either on a criminal charge or on the provincial one here in our example. And as well, at this point you're having those pre-trials, right? You mentioned the meeting an early resolution with the prosecution, or crown or judicial pretrial, on the criminal side. So maybe you can kind of explain a little bit about that, and then segue into talking more about some of those charter applications and the similarities and differences in the process with a criminal charge versus provincial offenses matter.
Right. So under Part 1, the whole premise of the provincial offenses is to try to simplify and not to try to bog down the courts with technical arguments. So under Part 1's, typically speaking, you will not have a judicial pretrial unless there's a multiple charter applications that may be brought forth, and they want to determine how long it's going to take to argue these charter applications, how many witnesses are involved in the trial, etc. When you're dealing with Part 3s or the criminal side of things, there's more issues that could arise in terms of disclosure and or the unreasonableness of time that it takes to come to trial, where you're now arguing a Section 11B. There may be multiple witnesses involved in a motor vehicle accident. And so the provincial offenses really wants to try to streamline. They don't want you to schedule a trial and realize that, we've only set an hour aside in this tier for your trial, but this may take, a full day or a day and a half or 2 days plus. So if that arises during a pretrial discussion with the Crown, then a judicial pretrial would be mandated, in which you will have to go appear before a judiciary as well as the Crown to discuss, if are there any agreed upon statements of facts, to try to weed out some of the witnesses. Okay, you're arguing a charter application. What authorities are you going to be bringing forward in terms of precedents, case laws? So if you have a book of authority, what cases are you going to be presenting? How long is that going to take? So that is all taken into consideration, and they might have to set aside what is called a special, meaning they have to actually look at the court scheduling and set aside, 1 full day, 2 full days, 3 full days, so that it doesn't tie up the regular courts where individuals are scheduled to appear. So that is an important aspect of the provincial offenses, and for criminal matters, for that under those situations where, if it's going to take a specified time because of the types of arguments or the number of witnesses, or that the facts or the evidence is so convoluted that they have to really go through it to determine, what is going to be agreed upon, what is going to be contested, then the judicial pretrial would be required.
Perfect. So I guess now we're kind of at the stage where there's 2 options. So let's look at maybe option A, which is uh, either the agent or paralegal or lawyer or self-represented party in either of these scenarios says, okay, you know what, I'm ready to plead guilty. What's important there, and we'll leave the sentencing piece for the end, because then there's the trial option, obviously. So what kind of goes in there? Now, you've touched upon again the importance of making sure you've requested and reviewed disclosure, and you've also talked about informed pleas, right? So when there's representatives, so maybe you want to touch on sort of what happens next if you're ready to plead guilty in part 1, part 3, and criminal matters.
Right. So there has to be a plea inquiry, because the justice has to be certain that the plea is informed. So one of the things they look at is it voluntary? Or is the plea coerced, or somebody forcing you, or you're pleading guilty for some other reasons than actually believing that you committed the offense? The justice would have to determine that again, the plea is voluntary, that they understand the repercussions of their guilty plea, so that they understand a conviction will be registered, and then with that conviction, there's repercussions that may occur. They would have to agree on the essential elements or the facts of what is being alleged. So upon entering a guilty plea, the prosecution may have to submit a summary or a synopsis of what the offense was. And they would have to acknowledge, yeah, that's essentially what happened. So they're agreeing to the facts. They have to understand that as a result of their guilty plea, there may be a monetary penalty or other repercussions. If there's demerit points associated with it and they're now above the threshold, their driver's license may be suspended. Depending on the what they're being charged with and what they're pleading guilty to. If you're pleading guilty to a handheld device, there's a suspension associated with that guilty plea. If you're pleading guilty to drive no insurance under a Part 3, they have to understand that there's a minimum sentence that is imposed, which is $5,000. So all of those have to be understood, and the agent, counsel, or self-rep would have to understand what those are. And the last thing that they have to understand is that by pleading guilty, they're actually giving up their right to having a trial. And sometimes that puts people their backs up when the justice says, "Do you understand that you're giving up your right to a trial?" And they go, "Well, what does that mean? Because I don't want to give up my rights to anything." So that just basically indicates that by pleading guilty, the prosecution does not have to prove the charge beyond a reasonable doubt at that point.
So then what happens again behind door number two, which is I'm not ready for that, right? I think I have a case. You mentioned, someone cut me off, or this accident happened in spite of my due diligence, or a reasonable and prudent driver wouldn't have avoided it. The things you're probably used
Yeah.
to. Or on the criminal side, right? It's perhaps it wasn't the best driving, but does it rise to the level of having the requisite actus reus and mens rea here? So what happens if for the trial? Like, how does a trial? How are they similar? How are they different in criminal versus HTA one?
So in both types of prosecutions, the burden of proof is beyond a reasonable doubt on the prosecution, whether it's a careless or a reckless under criminal code. The burden of proof is that the prosecution has to prove the charge beyond a reasonable doubt. In the criminal realm, again, we touched upon that the prosecution has to prove the mens rea element and the actus reus, whereas in the POA world, we talked about due diligence and strict liability. So, and strict liability is looked at on a balance of probabilities. What would the average person do in the same situation? So the justice looks at those type of fact situations if it's in the POA world. If anybody wants to really understand why there's different classifications of offenses, one could look at the case of Regina versus Sault Ste. Marie, which really outlines why the provincial offenses outlines the defense of due diligence. It's because it's quasi-criminal. A lot of offenses through the provincial offenses really don't have the mens rea element. Nobody drives their vehicle saying that I want to kill somebody, so I'm going to drive this way. It's usually an accident where they believe they were driving in a manner that they believe would have or could have prevented serious injury. Although when you're looking at careless, there are elements, and it's a high burden of proof on the prosecution. You know, there's case law which stipulates simply because an accident occurred doesn't mean somebody was careless. So that you have to look at the level of due diligence and the fact situation. If you look at a careless driving that's observed by an officer, let's say, rather than, and there's no accident at all, and they're following a vehicle and it's weaving in and out of traffic, it's not signaling, it's now going over the posted speed limit, it's gone through an amber light, and it's again making lane changes without signaling. Those are multiple types of offenses where a careless driving would fit. Whereas if they're just simply speeding and they're not going over an excessive speed, yes, it could be careless based on the traffic situation, but the burden of proof to prove without the other elements involved would be very difficult for the prosecution to prove for careless. So you really have to look at the fact situation to see what the facts are and if there's a reasonable prospect of conviction. And that's one of the most important responsibilities of a prosecutor is that they have to review the charging sections and the facts and determine whether it's there's a reasonable prospect of conviction and whether it's in the interest of the public to prosecute. So those are the things that you look at in the POA world, whereas in the criminal world, you really have to look at, again, any aggravating factors that were associated with the driving of the accused. Was there elements of recklessness or whether it could have been a snowy, icy day, and they're going, 50 kilometers over the posted speed limit. So they're not driving to the conditions of the weather as well. And an average person would know if you're driving at under those conditions and your speed is such that you are could cause a serious accident, that may constitute both carelessness and reckless, depending on if an accident occurred and the severity of damage to property or injuries to individuals.
Now, trial itself, I mean, is there anything different at trial? I mean, in terms of, the process of direct examination, cross-examination, re-examination, next witness, closing submissions type of thing. Maybe you can kind of outline if there are any things that, if you're preparing for the provincial offenses matter, the HTA matter versus the criminal code matter.
Right. So in that sense, again, we look at the parallels and the similarities between the two systems. And again, provincial offenses are considered what is called quasi-criminal. So it really mirrors the criminal proceedings. So when you're having a trial for either Part 1, Part 3, or a criminal, they follow pretty much the same process where you have your examination in chief and the prosecution outlines their case, presents all the required elements to prove the charge. And that is what is called a prima facie case. So you are presenting enough evidence for the court to understand that an offense has occurred. And the burden of proof on all three, Part 1, Part 3, and criminal, is again beyond a reasonable doubt. So that's the similarities. Then during a trial, the defense would have the ability to cross-examine any of the Crown witnesses and then be able to present their evidence as well. In the prosecution for POA, there is what is called a request for a directed verdict. If the defense believes that the prosecution has not proven the essential elements, they could ask for a directed verdict. In the criminal world, if the prosecution has not proven all the required elements, an acquittal will be entered. So they have very much similarities in terms of how the trial is presented and what the burden of proof is and how the trial is laid out. So after the cross-examination, if there's any new evidence that arises in the cross-examination, then the Crown would have the ability to re-examine and vice versa. The defense would have the same ability, and then you would have your closing arguments, and a ruling would be made.
Perfect. So, I mean, then the last thing, of course, is in the event, either there was a guilty plea or a finding of guilt at trial, you move on to sentencing, right? Now, going back to our I don't know, there's very vague details, but you can fill them in with whatever situation you want. Careless versus the dangerous driving there. What are and you brought up the concepts mitigating factor, aggravating factor before. So what kind of goes in terms of sentencing, and what are I mean, the other thing, I mean, people don't realize is you could still go to jail on the HTA side, right? So I mean, not obviously very common, but I mean, perhaps, in that Part 3, that might be on the table. So maybe you can kind of highlight, what are the possible sentences and aggravating and mitigating factors.
Right. So under Part 1, obviously there's the charter would apply as well, and there's no possibility of having any period of incarceration for Part 1. The Part 3s, there are certain sections of charging sections which stipulate what the sentencing guidelines are. And stunt driving, careless, and those type of offenses can have repercussions of incarceration. Very rarely under Highway Traffic Act matter would somebody be incarcerated unless they're, again, drive under suspension is another offense where an individual can be incarcerated. Typically for in the POA world, if somebody is repeatedly committing the same offense, and it could be in a regulatory sense, whether it be, and we haven't even touched upon other types of offenses other than Highway Traffic Act matters. It could be a fire code matter, a building code matter, a health protection and promotion act matter, a dog owner's liability act matter. Those are all prosecuted under the provincial offenses, but repeat offenders can be issued a probation order. And so if you're issued a probation order and you breach that order, again, jail time could follow. So that is something that can be looked at. But generally in sentencing, one thing to be mindful of, under Part 1s, if you decide to go to a trial, the amount of the fine, including the victim fine surcharge, no longer exists. So that is one of the risks that you run if you have a trial. So if you have a trial and the court determines that there are aggravating factors, they could issue a penalty up to a maximum of $1,000 under a Part 1. And under Part 3, it's $5,000. So there are repercussions in having a trial. And if there's evidence that is presenting that is particularly aggravating, then the penalties could be escalated. And or depending on the record, a probation order may be issued. In the criminal sense, there usually is a sentencing guideline in the charging section. And for reckless driving, I believe it's a summary conviction where the penalty can be no more than 2 years less a day and a maximum of $5,000 penalty. So in that sense, the justice would have the ability to be within that range, depending on the evidence that is adduced during the trial or during the guilty plea and what the fact situations are presented by the Crown. So Part 1s, once you request a trial, the set fine is no longer available, and the penalty is determined by the justice. Part 3s, again, the penalties, there's no monetary amount that is written on the charging documentation or the information, and they have the discretion to look at the fact situation and issue a monetary penalty that is fitting. And then for criminal, again, based on the sentencing structure of the code itself, they have some sort of guideline that they can follow as well. And then they could decide on time to pay. So depending on how much time you need, they can give you time to pay. And if there's any, if it's a Highway Traffic Act matter, demerit points may be associated with a conviction as well.
Perfect. So I think perhaps I think a great overview there. You have certainly students. I think I ran into you, and some student was sharing that, hey, that they may have an internship. So any of the students that are listening, future students who are interested in a career working as a prosecutor, in Toronto or wherever, any advice there of how to kind of build and get into that?
Yes. So it is very coveted to try to secure a position with one of the prosecutor's offices, and timing is key as well. I mean, during the COVID situation, where the courts were all closed, and even when the courts started to reopen, I can speak for the city of Toronto. We really wanted the students to have the experience to be able to do some of the work, be in court, and actually observe actual in-court proceedings. So availability of spaces are limited. And so any advice that I would give is that network. Depending on where you live, don't limit yourself to one jurisdiction. There's Mississauga, there's Brampton, there's York, there's Durham, there's Toronto, and even if you're willing to travel a little bit further to try to secure a position with the prosecutor's office for an internship, know who you're trying to contact. So try to find out who the managers are, and try to network that way. Obviously, because it is a very, I guess, demanding, and there's such a high number of applicants, we do look at the success of the students in their program. So GPA matters, previous employment matters. So any information that is relevant to prosecution or experience in prosecutions is key. So develop your skills, and one of the things I always talk about is if you do decide to go into a career as a paralegal, your reputation is everything. So how you present yourself, if you do get a placement, is very important. And continue to network, network, network. That would be my advice.
Perfect. So thank you so much, Michael, for taking the time to join us. Final question there, Bimmy, building on what you just shared. Any final words of wisdom for anyone else listening, whether or not they do want that career? But thanks again so much for joining us.
Thank you again for having me. But one of the other advice that I would have is that, as I'm starting to teach, I can see some of the students are kind of just walking through. Are we still recording? Walking through things and not critically thinking. So if you're interested in being a paralegal, critically think and prove what you're trying to assert. So some of the assignments that I've assigned, they've stated some regurgitation and some facts, but they're not really thinking critically. So as a paralegal, you have to assess all the information and look at various options. There's not a one-way way of thinking. You have to sometimes think out of the box, and that's what we're trying to get the students to do, is to critically think and to not look at the obvious, and to support your answers. So that is something that all students should be aware of.
Perfect. So once again, Michael, thank you so much for taking the time and joining us. And thanks for everyone for tuning in. Take care.
Thank you.